this is the state of Ohio versus Briggs, and the state has waived oral argument. And so you will have your full 15 minutes. And I don't think, we're being, you very well know we're being videoed, we're FaceTime live and everything else, and there are no victims that I recall that would be mentioned in this, that since this is a trespass, I mean, there's victims, but there's nothing, I don't think that we would mention any victims' names as well as children, but I just like to remind you of that. So you have your 15 minutes and you may begin.
You have to unmute.
Now you have to unmute yourself.
Okay. I was wondering if I was coming through the phone.
No, we're.
Okay.
Okay.
Good morning, Your Honors, and may it please the court. My name is Max Hirsch with the Ohio Public Defender's Office on behalf of Dennis Briggs. The trial court failed to ensure that Dennis Briggs had a full understanding of the consequences and dangers of self-representation before allowing him to proceed pro se in 2 trials. At most, the trial court only advised Mr. Briggs of his charges and the maximum possible penalties. Under this court's precedent, that information on its own does not effectuate a valid waiver of counsel. Accordingly, this court should modify Mr. Briggs' sentence by vacating the jail term. The outcome of this case is controlled by this court's 2012 decision in State v. Dowie, a case that the state has not attempted to distinguish in their brief. In Dowie, the defendant was convicted of a misdemeanor after representing himself in a trial. On appeal, he argued that the trial court had not fully advised him on the consequences and dangers of self-representation. This court agreed, finding that the trial court had failed to do so, finding that the court had only advised Dowie of the charges and maximum penalties, nothing else concerning the dangers and disadvantages of self-representation. Similarly here on the subject of self-representation, the trial court only discussed with Mr. Briggs the charges he faced and the maximum penalties. The trial court never discussed the dangers and disadvantages of self-representation, possible defenses to the charges or mitigating circumstances, nor did the court remind him that he would be held to the same rules of evidence and procedure. Therefore, by applying this court's decision in Dowie and the presumption against a finding of a waiver of counsel, this court should rule in Mr. Briggs' favor. I welcome any questions from this court.
Just wanted to ask you, Mr. Hirsch, in regard to the colloquy that he did have with him, he did talk to him about appointing counsel, about obtaining his own counsel. Obviously, the matter was continued a couple times. And so your main complaint is that he did not specifically go over possible defenses with the defendant before he proceeded pro se.
That's correct. What the trial court's obligated to do when a defendant indicates that they want to represent themselves, the trial court has to make sure that the defendant has a full understanding of the dangers and consequences of what that entails. And that might include things like defenses and mitigating circumstances. That includes things like a reminder that they'll be held to the rules of evidence and procedure, even though they're unrepresented. And the fact that the trial court discussed with Mr. Briggs or even recommended that he does obtain counsel, this court in Dowie and in Ott pretty clearly laid out that might be good practice and trial courts maybe should do that, but that doesn't provide information to a defendant that gives them a full understanding of what the consequences are.
And my understanding is that Mr. Briggs was not specifically asked if he wanted to waive counsel or proceed pro se.
I would say the record on what Mr. Briggs said about proceeding pro se is pretty ambiguous. I think there are some indications he said that he wanted to proceed pro se. The trial court seemed to understand what he said as an indication that he wanted to proceed pro se, but the issue is that when a defendant does that, when they make some indication or they affirmatively clearly say that they want to proceed pro se, that waiver of counsel, the waiver of that Sixth Amendment right, isn't valid until the trial court fully explains to a defendant what that means. They have to waive that right knowingly, intelligently, and voluntarily. So even if a defendant is emphatic to a trial court that they don't want a lawyer, they want to represent themselves, the trial court has a corresponding duty to explain the dangers and consequences of doing so. If the trial court doesn't do that and simply allows the defendant to go forward, the defendant hasn't done a knowing, intelligent, voluntary waiver, and under Supreme Court precedent and Ohio statutory law, that means that person cannot be sentenced to incarceration, and that's what happened here.
And that's what the remedy you're seeking is, that just that his incarceration and his jail time, incarceration time, be vacated.
That's correct. That's the remedy that's contemplated by the Supreme Court's case law on the matter in Argersinger, and that's the remedy based on Criminal Rule 44B. This court, as I outlined in my briefing, there are some exceptions to that. None of them apply here. The default remedy is to affirm the convictions but vacate the jail time.
Mr. Hirsch, I have a question about the conversation in the record from the trial court related to, and the Mr. Briggs related to his concern over the costs of representation. Can you explain to me what role, if any, that plays in the what you might submit was an invalid waiver?
That shouldn't play any role in the court's analysis, I don't think, or at least I don't see any reason in the case law why it would. I think Mr. Briggs was just concerned about having to sign off on his indigency, and whether that understanding on his part was correct or misguided or whatever else. At the end of the day, when he did indicate that he wanted to go forward and say, I don't want a public defender because I'm concerned about this payment, I don't think that changes the analysis in terms of what the trial court's duty is in explaining, okay, well, if you do that, then here's how it's going to go going forward. I really encourage you to get a lawyer, but the trial court has to lay out all these different consequences and dangers, and at the end of the day, that's what the trial court failed to do.
And Mr. Hirsch, on the issue of consequences, the consequences of the sentence that you request, I of course read your brief and your reply brief, and as well as obviously that of the state. You're asking for a sentence modification that just precludes the imprisonment portion of the sentence, but not the conviction portion of the sentence. Can you just amplify a little bit more about why you think that is the correct route?
Well, it goes back first to the United States Supreme Court's Argersinger decision in 74, which said that a person, even when it's a misdemeanor, if the person's right to counsel is violated because they didn't validly waive, that person can't be sentenced to any form of incarceration. Very shortly after that, the Ohio legislature codified that rule into Criminal Rule 44B, expressly saying that if a defendant doesn't knowingly, intelligently, and voluntarily waive the right to counsel, that person cannot be sentenced to a term of incarceration. The Ohio Supreme Court understood that in its, I think, the Gibson decision in 1976, and really, if you want to even go deeper, it really goes back to Gideon versus Wainwright, that a person charged with misdemeanor, if they can't afford the lawyer, they have a right to one, and it's a very serious thing for the person to waive that right. So they need to have a full understanding of what that means, and if they go forward without that full understanding, it would be unjust to throw that person into prison or jail.
Mr. Hirsch, but what about the point of the conviction? Why is it then, why is it your position that the conviction should stand?
Well, a conviction is obviously a serious thing. I mean, and I guess I would just fall back on the case law that Ohio courts have pretty consistently applied, that when there's an invalid waiver of counsel, the rule is that the conviction stands, but the incarceration, is not going to be valid. And I think the reason for that is, while a conviction is serious, the deprivation of liberty by incarceration is even more serious on a different level than the fact of a misdemeanor conviction, which can be sealed after a certain amount of time and under certain circumstances. So that's just the case law, and I think that's the principled reason why a conviction can stand despite an invalid waiver, even if someone can't be incarcerated.
Thank you.
Counsel, I haven't read the full transcript to see exactly the words that the court used throughout the proceedings. But is it appropriate for the court to use a substantial compliance analysis in looking at not only what the trial court said, but in conjunction with what perhaps Mr. Briggs was advised at his arraignment concerning the nature of the offense, the level of defense, the range of punishments? Is that an appropriate analysis?
I'm not sure that it makes a difference here. In my research, the substantial compliance language can be found in all kinds of felony cases involving waiver of counsel in 44A. I think I found maybe one case in a 44B context where a court used the language of substantial compliance. But regardless of whether this court calls it substantial compliance or calls it a knowing, intelligent, and voluntary waiver, the result has to be the same. This court's decision in Dowie is controlling. It can't be substantial compliance only to advise someone of the charges and maximum penalties. And that's the bottom line, that even though the standard may be flexible and there may be close cases, this is not a close case.
Well, one of the questions, in Dowie, they found that the court needed to advise the defendant that he had to follow the rules of evidence and procedure. And in this case, I believe the court advised, I strongly urge you to get representation, consult with an attorney for assistance. Was that the extent of his discussion on that with the defendant? Again, I haven't read the exact wording in the record yet, so that's why I'm asking the question.
Yeah, and I think at most the trial court said, I really encourage you to get a lawyer to help you out. In my opinion, that doesn't rise to the same kind of advisement as, if you take this to trial, I'm going to hold you to the same rules of evidence and procedure as if you had a lawyer. Those exact words or something similar to that was never anything the trial court said. And like this court has pretty consistently said, simply recommending that someone gets a lawyer does not advise someone of dangers and consequences of self-representation. So the trial court maybe easily could have said that in kind of the same breath, but it did not here.
Thank you.
If this court has no further questions, I'll conclude by saying that this court has consistently and clearly held that a defendant does not validly waive the right to counsel when they're only informed of the charges and possible penalties. That information on its own does not ensure that a defendant has a full understanding of the consequences and dangers of self-representation. Because the trial court here failed to provide any information beyond the charges and maximum penalties, Mr. Briggs did not validly waive his right to counsel, and this court should vacate his jail sentence.
One last question. I'm assuming there was no written waiver of counsel in this case.
Correct.
Thank you, counsel. The court will take the matter under advisement and will issue a written opinion that will be sent to you and to the state, obviously, to both parties. And you can also look on our website for our electronic release. Thank you.
Thank you.
I hope you have better luck with the other Zoom calls today.